Now, for some legal expertise on that story, we are joined by Advocate Kamogelo Maputla from the Tshwane Society of Advocates. Thank you so much for joining us this morning. According to the Constitution of South Africa, what would stand in court to grant for postponement of elections? I know you were listening in and quite a few legal arguments being raised. Your thoughts in terms of the proceedings of this morning?
Thank you very much. Good morning to your viewers and listeners. What the court is likely to consider is the first element of the human interaction, because one can never divorce themselves from what is free and fair and what is regular. In terms of the Constitution, in particular Section 19.2, it says that every citizen has the right to free and fair regular elections. Now, from what we have heard, Mr. Trongov's comment and make submissions about is that there are three elements of the case before the Constitutional Court. That is the free and fair, that is the safety of people, which no opposition can actually deny, because the practicalities of whether or not the elections are likely to happen, as evidence is going to be led, and on the robust data in the public domain, we can all partly say that it is an impracticality for the time being. However, what one must never forget is that when all factors are considered, the COVID scare will still be there, whether it's now or next year. Now, on the questions that Justice Theron had asked, to say that isn't there a likelihood that the Commission has made a late reaction to the delay in preparing itself? And Mr. Trengov astutely responded and said that no, the processes were always there, and he has undertaken that they are in the public domain. But what is more important is that South Africa, in particular, the government has to put in infrastructure that is going to ensure that the safety of all voters is there, the confidence in voters is there, and the elections are free and fair, as the Constitutional Court has previously ruled on the issue of what is free and fair in 2011 in the Electoral Commission's case against the IFP, and in Khan in 2015. And in particular, we all know that the electoral process are complex, require careful consideration, planning and preparation to ensure that they are free and fair. What struck out in the discussions this morning was the financial aspect, which most of the oppositions have not even considered, because what is inevitable is that should there be a press to chase the deadline, there are financial implications, which if the elections are not free and fair, then the public funds are the ones still to be used to come and correct the run again of the elections.
We'll talk about that financial aspect earlier, but quite a lot of time was spent on trying to determine exactly what it is that the Commission is asking the Constitutional Court to do. At some point, there was a conversation about determining whether it's constitutional or unconstitutional to postpone, and also leading to that question about whether it's an amendment or a postponement. How are we to engage with this conversation as non-legal beings?
As non-legal beings, it is quite simple. We first look at what is the primary argument that the Commission has brought to the court. And the primary argument is that there are three primary requirements, and we must never put one over the other, because the only safety net that no one can disagree with is the safety of the elections and in particular the citizens. But the alternative argument, which, if I may just quickly remind myself, they ask for what is just and equitable under Section 172. This ordinarily happens when the court finds that what you have done or what you are planning on doing, though a lot of water has underwent the bridge, it is now required for us to actually intervene and tell you, under the circumstances, all factors included, because we must never forget that there are diverging views of the medical experts. And we all know that this case is a fusion or a battle between the compliance with the law and respecting the right to life, which the experts in the medical sphere are actually concerned about. And when there is that diverging view, the court must take a frictionless point to actually harmonize all the submissions by the parties concerned and come up with what is just and equitable after all evidence has been considered.
Just unpack for us that financial aspect you were referring to earlier.
Thank you very much. The financial aspect that is involved in the current application is that, let's assume for a moment that the elections are to proceed as the deadline is being chased. What is the likelihood that they will be free and fair? There are certain cogent arguments made by Mr. Trongov say that we must never forget that there must also be a benefit to the smaller parties. We must not only listen to what the bigger parties with more coffers have. Now, the financial aspect would be that the Commission is a Section 9 institution. It derives its funding from the public funds. Now, if the public funds are spent to a useless process which is going to have a rerun, it would rather be safer not to spend those funds. It would rather wait until I'll harvest the words used by Mr. Trongov, until the trough, which is also questionable, because if the experts say it might even be safer now in October vis-a-vis in February, because in my considered view, the KZN and Northwest have not yet, KZN and Western Cape have not yet reached their peak. So how do we know whether the trough will be reached as contemplated? That is the difficulty. But on the financial aspect, it is just based on that, say that we would rather reserve the amount of money allocated to run free and fair elections now that we have established that there are difficulties both on structural and logistical difficulties.
Thank you so much, Advocate Kamogelo Maputla, for speaking to us this morning.